Yes, Mr. Wood.
My Lord, the rest of my team isn't here, and I'm almost certain that I'm to blame for it, because I thought I was running late and came straight here rather than going via their conference room, and I suspect they're waiting for me. So I apologise, and not on their behalf, but on mine, because it was my thoughtlessness that I suspect has caused this slightly embarrassing absence. So
it's all right.
Anyway, I know that your Lordship will hold it against them, and you've got many other things you can hold against me. My Lord, briefly to reprise before I give way to my learned friend Mr. Weir, we say the argument that the statutory award is an award for all general damages caused by the whiplash, even if they also have a concurrent cause, is to extend a statute addressed strictly to a narrow subset of whiplash claims much too far, and leads to it impacting on compensation it wasn't intended to impact on. And so it isn't the result of a purposive construction. We also say, to the extent one can glean clues from the statutory language, that it is contrary to the statutory language, in that the statutory language simply makes it clear, this is 3.8, nothing prevents a court awarding amount of damages for general damage that reflects the combined effect of the person's injuries. And there's certainly nothing in that statutory language which compels the court to attribute to the statutory award the whole of the concurrent damage, rather than simply to that award that which is, as it were, its share of the concurrent damage. It doesn't force one to focus the entire concurrent damage into the statutory award. Rather, the court it's an unfettered power of the court to take into account an award an amount of damages that reflects the combined effect, and the combined effect, obviously, we say would pay heed to the established common law value of the non-whiplash injuries. And that approach is also faithful to the principle that the Act is assumed to modify the common law to the least extent necessary in order to deliver its statutory purpose. And we say much the same in respect of what I called the reprise at section 5 of the Act, when it talks about how the exceptional uplift is to impact in mixed cases. And it simply refers to the court taking into account the tariff amount when deciding the amount of damages payable for general damages in respect of the injuries mentioned in subparagraphs 1 and 2. Subparagraphs 1 and 2, that's the scheme injury and the non-scheme injury. Again, there's nothing there in any sense prescriptive as to an inclusion exclusively within the tariff amount of all that is common to both tariff and non-tariff injury. Our approach also doesn't offend the policy of the Act, because the whiplash element is still reduced and the ambit of the small claims track is still enhanced. And if you ask yourself this way, a useful test of whether the Act is offended, or the policy of the Act is offended, is to imagine, well, suppose the claimant was a motorcyclist, but the facts were all other ways identical. Would his damages still be less, as the Act clearly intends? And the answer is yes, of course they would still be less. They would be they are considerably less because of the suppression of the statutory whiplash element. My Lord, our approach doesn't create any common law difficulty either, as the concern of the common law is to ensure that damages for different injuries of similar effect are proportionate and consistent. So obviously one of the things the common law is always very concerned about, and it's one of the reasons behind the Sadler totality principle, is you might, if you just totted up a sequence of diffuse minor injuries and added them together, you would probably emerge at a total amount, which is considerably more than the court might award for a unitary injury that was actually more severe in its effects. The pain and suffering from a broken leg is likely to be more from the pain and suffering from bruising, even if the bruising is at multiple sites on your body. And that's the concern of the common law as expressed in the authorities. It wants to make sure there's consistency and proportionality between awards for different sorts of injury. But our approach doesn't create any difficulty with that, because in no sense does the claimant who has a mixed injury which includes a whiplash element get more than claimants with comparable but non-whiplash injuries. In fact, they still get less because of the Act's suppression of the value of the whiplash element, albeit on our analysis, the value of the balance of the injuries is maintained. So far as the point which my Lord the Master of the Rolls was putting to me about, well, you know, how can it, what is the explanation for what is a subordinate injury, like an injury to the knees in the Rabot case, having a greater value in the hybrid assessment than it would in an Lodestar common law assessment? Our answer to that is firstly the answer I've already given. That is simply a consequence of the partial intervention of the common law simply to suppress the value of one aspect of a composite sequence of injuries. Secondly, in fact, it is, in terms of value, it is no longer the subordinate injury. Because of the intervention of Parliament, the knee injury is in fact now worth more, and there's no conceptual difficulty with that. It's simply a consequence of the intervention. And lastly, it doesn't in fact have a greater value. The value of the knee injury is the value it always had, but it simply has a greater prominence and therefore contributes a greater amount to the overall pot, because the Act has suppressed the value of a different aspect of the claimant's personal injuries. But the knee injury itself is still tested against the unchanged common law principles, which are now reflected on the authority of the Privy Council as a primary source of law rather than a distillation in the Judicial College Guidelines. And the Judicial College Guidelines for a 6-month injury to a single knee, £2,250. This district judge allows 2,500, stressing, well, it's an injury to both knees. That is an application of the law unchanged as it is in our submission by the Act. So coming on lastly to the secondary approach, the district judge's approach, which I mean, my learned friend, Mr. Adams, has a certain amount of sport for the fact that we say in our skeleton it's rational. I have to say it's not particularly good sport, because we say expressly, well, it's rational on the hypothesis that we're wrong on the first points, and on that hypothesis, yes, and I'm unabashed in commending the rationality of the district judge's approach. It's a rational alternative. A modest adjustment to reflect what we have to posit is some element for loss of immunity that is buried into the statutory award. But the sort of relatively modest adjustment which she applies, at least in the case of Rabot, in our respectful submission, she's absolutely right that it's modest. And the reason it should be modest is this: whatever is subsumed into the statutory award is clearly small and much less than would be present within a common law award, and that's what matters to the purpose of the non-statutory injury. Secondly, of course, we mustn't lose sight of the fact that general damages consisting of pain and suffering, loss of immunity, and the pain and suffering is going to be distinct. It's different having pain in your knees and having pain in your neck. And in these small cases, I appreciate there's no science to it, but I would suggest that in these small cases, actually, really the primary focus of the solatium for general damage is likely to be pain and suffering, because the loss of immunity in these small cases is usually pretty small. And again, Rabot is a nice example of that. As my learned friend Mr. Allen showed, the only thing that's recorded is he was uncomfortable when he's taking out his bins, which for some of us is once a fortnight. It's not like a more serious injury where one may have to give up a sport, or one is no longer able to engage in some sort of pastime which is central to one's life or would affect your intimate relationships or whatever it may be. There's just no parallel to those sorts of losses of immunity which are used to in bigger cases than these little cases. So a modest adjustment of the sort that the district judge made in Rabot, we pray and aid in the alternative, and we respectfully, on the hypothesis we're wrong on our primary case, adopt her reasoning as our secondary case. The only wrinkle to that, as you've seen from my skeleton, I don't really propose to deal with it orally unless you want me to. I'm just respectfully reminding the court, is we do say, notwithstanding the deference which must be paid to the learned district judge, assuming she's correct in her methodology, we do say that her methodology goes wrong in the Briggs case, because she actually, having come to a conclusion as to what the non-scheme injuries are worth in Briggs on a conventional common law basis, which nobody challenges, she then reduces the overall amount of the award as part of her Sadler adjustment to less than the amount that she said that she would have awarded for the non-tariff injuries alone. And we do respectfully say that in an otherwise careful judgment, she thereby took her eye off the ball. And even if the court is with the learned district judge on her methodology, she applied it wrongly. And we make some submissions about where we say that leads in our skeleton. So don't propose.
But that doesn't work, does it? If you're wrong about the principle, which is that you are given full compensation for pain and suffering and loss of amenity suffered as a result of the whiplash by the tariff award, and therefore you don't get double recovery and you don't get any more, that may well result in an award that is less than the common law damages would have been if you'd been compensated on that basis.
Oh yes, I agree. And that's of course one of the reasons why we say that that exposes a fallacy in my learned friend Mr. Allen's approach, because that's an unprincipled outcome. And I'm either right or wrong about that, but I certainly accept that if I'm wrong about it, then that outcome may follow. I have to say, I wouldn't, we're not really here to talk about figures probably. I wouldn't, for my part, be quite so austere as Mr. Allen, even on his analysis, because it probably puts too much emphasis on loss of amenity, which is, it's because it's that where there would be the concurrency, which on his analysis needs to be stripped out. Whereas in these small cases, as I've already said,
here, what he should be compensated for is not loss of amenity, because he's already been compensated for loss of amenity. Even if Mr. Allen is right, he should be compensated for the pain and suffering in the knees, and that would not be so small. Which is
not de minimis. No. And as I say, I quite accept that there may be other areas where you think that within the Judicial College amount, there might be quite a lot for loss of amenity, because you can assume, for example, take a Grace example, a person who's lost a leg, it's obviously that's going to cause him loss of amenity in every aspect of his life. But when you're talking at this level about soft tissue injuries that are essentially invisible, probably the pain and suffering, which is going to be distinct, is the principal thing that's being compensated, because the sort of losses of amenity we're talking about is a chap not being able to put out his bins, or a chap maybe having to take a couple of weeks off of doing his workout, his sort of twice weekly workout. We're not
Might
talking
not be
about
a chap.
Well, or chap S, quite. It's not likely to be in any of these cases a radical and transfigurative loss of amenity, as there might be in a ward where the injury was more gross. In a case where the injury was more gross. My lord, those are my submissions, unless there's anything I can assist the bench upon.
Other than chap S.
Yes, I'm not sure chap S improved chap, but anyway.
No.
Well,
there we are.
It's not a technical term that I recognise, I don't think. No questions from me.
Thank you very much, Mr. Williams. Yes, Mr. Ware.
May it please the Court, in our written submissions we sought to be constructive in the sense that we sought to take from the ground up the analysis of in our respectful submission, the relevant statute and the effect it has on the question before the Court. In my oral submissions, may I be forgiven for being somewhat more destructive and focusing on the way in which the defendant presents its case and seeking to address that case and give my responses, which will all come out in the wash the same way, but I'm not going to start straight by going into the statute. The defendant's case operates as follows. The cornerstone to its case is that the tariff award compensates the claimant for all the pain, suffering, loss of amenity attributable to the tariff injury. That's set out in their Briggs skeleton at para 36, core bundle, page 17 for reference. Clearly we've got there through the course of oral submissions during today. And the next stage in their argument is as follows. This means that to avoid double recovery, sometimes also being referred to as double counting, but I prefer, if I may, double recovery, the court should only compensate the claimant for the additional pain, suffering, loss of amenity caused by the non-scheme injury. And that's the synthesis that my Lord and Master of the Rolls reached shortly before lunchtime of the issue before the court and the way in which the defendant's putting its case. And that's also set out in a number of places in their second skeleton argument in Briggs, paras 13 to 16, core bundles 60 to 61. I don't invite it being taken up, but for the avoidance of doubt. And I would add, this necessarily also involves taking the tariff injury as the starting point. And you see that in their Briggs second skeleton argument, para 44, core bundle 66, and see the observations of my Lord Justice Stuart-Smith to that effect, that's what the defendant is doing. It's saying take the whiplash first, see what's additional, by reference to the discussion in the case of Connolly. And why and how the defendant's analysis respectfully unravels, I've got 4 outline submissions. I'm just going to take them in turn. The first one is because awarding full compensation for the non-scheme injury does not offend against the principle of double recovery, which is the foundation stone of the defendant's case. The defendant has used the word compensates when describing what the tariff award does for the whiplash injury. And it's only using the word compensates as a jumping board to its core assessment that in order to avoid double recovery, given the claimant has already been compensated for all the effects of the whiplash injury, that the court should now only compensate the claimant for the additional effects of the non-scheme injury. But the principle of double recovery only arises in the context of the underlying principle of full, sometimes referred to as 100% compensation. And back in the day, in the Livingston case, the principle of restitution. So the principle that invites the court to award...
So where do you say the principle comes from?
I beg your pardon, my lord.
Where does it come from?
It comes from Ray Yardson's Livingston, my lord, and it's set out in the opinion of Lord Briggs, very conveniently, in the Attorney General against St Helena case. If I just take you to that, my lord, it starts at page 294 of the authorities bundle. That's the opinion of the Privy Council recently, which ends up being an incredibly helpful summary in relation to the law for compensation for non-pecuniary damage.
With great respect to the appeal from wherever it was, there must be some authority before 2020 on this point.
Oh, there's ample authority. We've got the Limpo Chew case. We've got Highland Rankin.
Could we just look at the sort of more traditional authority before looking at the new synthesis? What is the case that...
My lord, yes, but can I just start at page 302, if you'll allow me to, paragraph 22 of Lord Briggs's opinion, because it's really pretty helpful in terms of setting out the position. Your lordship will see, if your lordship has, it's page 302, I hope, for you as well. Para 22, the core function of pain, suffering, loss of immunity damages, like any other type of damages, is that identified by Lord Blackburn and Livingston and Rayards, or Royards Coal Company. And I won't read out, but your lordship can see that's a now famous passage.
Yes.
That's what I'm calling the principle of restitution. That's what it's often referred to as, but it then became called the principle of full compensation. Mm-hmm. And you'll see reference there to Highland Rankin, referencing in the judgment of Lord Wolfe, Master of the Rolls at para 23, this principle of full compensation. Yes. And we have the Highland Rankin judgment in the bundle if that's of assistance to the court to see that in more detail.
So that's set out at paragraph 22 of St Helena.
My lord, yes, that's at page 216 and para 22. You'll see.
What's your point?
Yes, my lord, that's the principle of full compensation.
Yes.
But when the defendant is suggesting that the tariff award compensates the claimant for all the pain, suffering, loss of immunity attributable to the tariff injury, in order to engage the principle of double recovery, it must be saying the tariff award is providing full compensation. And that indeed is the expression used by my Lord the Master of the Rolls only recently. Otherwise, the principle of double recovery simply does not come into play.
I don't understand. I don't understand at all. The statute says what full compensation is for a whiplash injury and all its consequences.
My lord, This is use of the word compensation, which is a word which is very susceptible to its context in this way. Is it compensation rather than, for instance, punitive damages? Of course. Is it therefore appropriate, as I think there's a reference in learning from Mr. Allen's skeleton argument to a judgment from Mr. Justice Edis in relation to what bereavement damages, statutory fixed in law award of bereavement damages is, which he describes as compensation. So in that sense, one can understand why one says it's compensation.
You can use any word you like, Mr.
Yes,
Ware.
but my lord, it's not full compensation, because full compensation is the common law cornerstone principle of full reparation, full restitution, 100% compensation. And that
This is a really difficult submission when the explanatory memorandum, I'm just looking at page 402, says, as such, controlling the costs of civil litigation for whiplash claims whilst ensuring proportionate compensation
my lord, yes.
is paid. Surely we have to take it that where you're within the scheme
Yes, my lord.
of the Act, it is to be treated as appropriate, proportionate compensation.
My lord, depending on exactly what...
It's definitely less than common law
Yes, my
damages.
lord.
That we can all agree about.
But that very much depends, my lord. It's not it's very difficult to say yes, no, because then it only begs the question, what does one mean by proportionate and fair compensation in that context? It's going to go to my apples and pears submission in due course. Can I just start with statutory bereavement award, because it's something different, but if we can just reflect briefly on statutory bereavement award. When advising clients, as we do on a recurring basis, we do not say to the client, Parliament has deemed that your bereavement for your long-loved spouse is measured accurately and fully in accordance with the principle of full compensation. Here's £12,980. We say to the client on a regular day in, day out basis, this is a notional amount that is fixed by law in recognition of your loss, because Parliament has made a policy decision not to go behind the veil and not to investigate what bereavement you have suffered. And that is what Parliament has done here. Parliament has made, for good policy reasons that we are not here to challenge, to do with simply depressing or suppressing the amount of money that's recovered for whiplash injury, and amongst other things, discouraging fraudulent or exaggerated claims. See the explanatory memorandum we've referred to in our written submissions. Parliament has said there will be no investigation, brackets, beyond duration of symptoms, for the purposes of assessing the right part of the tariff of your pain, suffering and loss of amenity. And that is why, respectfully, when it comes to the issue that my Lord Justice Stuart-Smith has raised of, well, we don't know how much, it could be 50 quid of the 500, we don't know how much. It isn't 50 quid of the 500, it isn't anything. There is no assessment
It's in there. It's
no,
in there.
my Lord...
Because under the scheme, what you get from the tariff is your compensation for pain, suffering and loss of immunity. And it covers all aspects of pain, suffering, loss of immunity attributable to the whiplash.
My Lord, yes, but respectfully, yes, but sort of and no, in that yes, my Lord, it compensates. I'm content to use the word compensates in that context, but that's the context in which it's being used. It does not intend to or achieve the outcome of full compensation, because full compensation is to identify the pain, suffering, loss of immunity of the individual, and to say,
So
you have
Mr. Ware,
suffered.
Can I just ask you this, and then I will shut up. Parliament has said that full compensation for whiplash injuries, proportionately judged, is going to be very low, right? You accept that?
My Lord, I'm struggling with the word full, if by
Well,
full.
they've said the amount of compensation
Yes, my
for
lord.
whiplash injuries is going to be very low.
Yes, my Lord, that is right.
So how can the court say that it can compensate for the same injuries with another figure?
Because, my Lord, what Parliament has done, and it gives rise to this particular problem because it's a partial intervention. This is where the problem arises. Statute of bereavement award sits on its own, and there's nothing to come near it that has to be measured or impacts upon it. But in this context, Parliament has simply said, exactly as your Lordship says when one goes back to section 3.2, the amount of damages, it doesn't say full compensation, it says nothing of the sort. It says simply the amount of damages is an amount specified in the regulations, which we can put into shorthand of fixed by law. So it just says the amount you will recover is fixed by law. It does not say in any way, shape or form this is providing full, meaning 100%, meaning the principle of restitution is being applied, compensation.
Completely get that.
But because it doesn't say that, you don't enter the arena of double recovery. That's a misstep, respectfully. Complete misstep. To then leap from the position where you've been given an award. The award could have been nothing, as I think was raised by the bench. Today it could have been you will have no money. The amount of money is nil, or the amount of money is £10 to really make it extremely low, or whatever. It doesn't matter because it said this is an amount which is not measuring. The purpose of full compensation is to put you back in the position you would have been in. That is not the exercise which is conducted at all. And so the problem of double recovery does not arise. That's the point. We don't leap from here's a fixed by law award to any more than ordinary compensation for your non-scheme injury will offend against the principle of double recovery, which is the cornerstone of the defendant's case. We don't get there. Because you do not need to limit damages for the non-scheme injury to additional pain and suffering to avoid double recovery. We are not logically in a world in which the court can assess double recovery because it can't assess full compensation. We come back to this when we look at the fact that we've got these two separate awards. This is the very problem, and Parliament has answered it by section 3.8, which I'm going to come to. Moment. So the defendant's case necessarily assumes that Parliament has intervened to limit the recovery of damages for the non-scheme injury. This is my second submission.
Sorry, just say that more slowly.
Yes, my Lord.
Necessarily assumes that Parliament has
intervened to limit the recovery of damages for the non-scheme injury when it has not. Now, this is the observation of my Lord the Master of the Rolls, and the observations and the reason my Lord, if I may speak respectfully, my Lord Justice Stuart-Smith kept coming up against a brick wall when he was saying, but you say you accept the common law applies to the valuation of the non-scheme injuries, but how does that fit with your case? And the reason it didn't, because that's why the observation of my Lord and Master Rolls must be right, that the defendant's core submission, whether articulated or not, is actually that the Act has impacted negatively on the valuation, the common law valuation of the non-scheme injury. That's why it all becomes a matter of statutory interpretation. So they say that's not their case, but it actually works out that it must be. Because what they say is Parliament's intervention into whiplash has limited the claimant's recovery for the non-scheme injury to the additional pain and suffering caused by that injury.
Yeah, where the consequences overlap.
Where in the case of concurrent causes, my Lord, absolutely. Yes.
If you're wrong on your first point, then you would have to concede that there's got to be some adjustment, wouldn't you? Well, even if we can't identify what the amount, which we clearly can't.
My Lord, no. It's first of all. I took that as a first point, but I would invite you to hear 4 points, because one goes to the wording of section 3.8 and one goes to practical consequences, each of which stand on their own 2 feet, if you want to put it in that way. I don't say our case collapses if the way in which I propose the court analyses the invocation of double recovery as the mechanism to break our case is wrong. We say it's just wrong, the wrong invocation. It's been called out. This is all about double recovery or double counting in circumstances where we're not in a world of double recovery. We can't be, because you're seeking to measure double recovery against a figure which bears no relationship to your pain, suffering, loss of
Not in a world of 100% double recovery, but you are in a world of two awards in respect of the same PSLA.
My Lord, but that's why I put my submissions through in stages and made the submission which the court can accept or not accept, but in my submission has to be right, namely that the principle I would describe it of seeking to avoid double recovery is only engaged as an adjunct to the principle of full 100% compensation. It's the only time it's engaged. I should also add that the principle of avoiding double recovery is not absolute. In the world of mitigation, for instance, if a claimant cannot reasonably be expected to mitigate his loss and obtains a collateral benefit exceeding full recovery, that is allowed. I'm pretty sure that's Lord Hope in Lagden and O'Connor, or is it? Yeah,
Lord Hope in what?
Lagden and O'Connor, my Lord. I'm not sure. It may have involved my Lord Justice Stuart-Smith. Many of these cases
I don't really care who
did.
it involved, but I'd like to reference, please.
Yes, of course.
I'd like to look at it, not just have cases thrown around as that's the law.
Apologies.
I
my Lord,
need
yes.
to know where the law is and
My
where
abso-
it's stated
my
and
Lord-
be shown it, please.
Yes, I do.
Yeah, thank
My
you.
Lord, yes. My Lord, we'll possibly, if the court can tolerate it, send a short email with the reference and attach an
You can
electronic
send it
copy.
to me later. I just
Yes.
want it. Yeah.
Thank you, and apologies. So the principle of avoiding double recovery is not absolute, and it only flows in the context of a world in which the court's primary task is to provide, and I sometimes call it 100% compensation because it makes the point, it's 100%, it's not 110% or 90%. It's neither more nor less, but it's full 100% compensation. If you're not in a world where you can measure full compensation, it doesn't materially arise for this court the concern that it then says, but this way I will cause double recovery. You won't. You don't engage it relevantly. And that's the difficulty with just using the word compensation as the trigger for leaping to, oh, this involves double recovery. And that's absolutely the heart of the defendant's submission. Take that away, there's nothing left. The second point I'm seeking to make is the defendant has to say that Parliament has stepped in to limit recovery for the non-scheme injury because the defendant is not accepting whatever its submissions are in substance that the claimant is entitled to have his or her non-scheme injury assessed according to common law principles. Echoing the observations of the court this morning, see my Lord Justice Stuart-Smith and concurrent causes, this issue could be put in the following way. It's an issue of legal causation. So, where in a case, as a matter of fact, the defendant's negligence has caused a range of pain, suffering, and loss of immunity to the claimant's knee, as a matter of fact, as a matter of law, is the claimant limited to recovery only for those symptoms additional to the symptoms caused by a different injury, namely the whiplash injury? That's legal causation. And normally we talk about that in a pure framework of the common law, and then we'd refer to things like Bonington castings, and my Lord will forgive me, but these are I didn't want to overburden. We're normally told 10 authorities, no more, and it's very difficult to know the extent to which we should produce more authorities on the off chance we're going to go into that arena. But it's all Bonington Castles, McGee, and more recently Privy Council, Williams and Bermuda Hospital, all of which sets out that provided the claimant can establish that the loss, and we often enter then a world of non-divisible injury, for which our loss of amenity example fits very well, the inability to play badminton, provided the claimant can show that the knee, I'm just taking a knee for shorthand for non-scheme injury, the knee injury has materially contributed to the loss of ability to play badminton. The full loss of ability to play badminton is recoverable as a result of the knee injury. That is a different way of making the same point as the observations of my Lord Justice Stuart-Smith repeatedly this morning. In my
well, that's what we were talking about when, from time to time, we reverted to the idea that the claimant has two injuries from two different tort treaties.
My Lord, yes. I'm just articulating
these are
slightly different way, but
same
substantively the same point. And your Lordship has simply put it in what I respectfully call a shorthand of concurrent causes. Take it as read, and I'm simply trying to draw out that I say that that is an issue of legal causation. Put back in a statute, the question, because I understand very well that my Lord Master Rowe is always keen to shake, and see what comes out, and reduce until we get to the nugget and see what it really is. But putting it back into the statute, has Parliament, through the 2018 Act and its associated regulations, altered the common law test of legal causation in respect of the non-scheme injury, is how I would respectfully seek to put the issue before the court, and to which I would give a very firm answer, not at all. And my learned friend accepts that the common law applies, but as I say, it's rather difficult to understand how in his case it does. But we say he's right to accept the common law applies, and see the submissions which we've made in writing in relation to derogation from the common law. That's paras 47 to 53 of our written submissions, my Lord. And I don't
I'm sure you'll give me the reference of the other two cases you've mentioned.
My Lord, the Bonington Castings and,
yeah.
Yes, my Lord, and the McGee and Williams, the three cases, well, again, make sure they're electronically sent forth to the court, if I may.
Thank you.
So, my Lord, that's the issue, and Parliament has in no way overreached itself as it would do, as it could only do if it did so expressly. In that way, my own friend, in response, Mr. Williams, in response to the observation from my Lord the Master of the Rolls that we may have to look at a purposive construction, is, in my respectful submission, entirely right. You absolutely can't say Parliament intended that outcome, because the focus of Parliament's attention in this context is just on the whiplash injury.
Do you really, can you really say that, Mr. Ware? I mean, if you read the explanatory note,
Yes, ma'am.
and you read all the material, which this court is incredibly familiar with, the idea of this was to reduce compensation for small claims, personal injury claims, which normally took the shape and form of whiplash. And what's happened here, in reality, is that there's been displacement activity. People who suffered whiplash used to say they were happy with the £3,000 or £4,000 they used to get, and they didn't bother to say, oh, I hurt my knee in the same crash. But now they say, I hurt my knee and I would have got £5,000 for that, so I'll have the 5,000 anyway. Now, you may say, well, that may be what Parliament would have liked to do, but it didn't do it. But the reality is that it makes no logical sense to say they want to control the cost of civil litigation for whiplash claims whilst ensuring proportionate compensation is paid to genuinely injured claimants, and then they get the proportionate compensation for the back, which goes on for 10 months and is very uncomfortable indeed, is £500 or or whatever it is, and the compensation for the knee, which goes on for 6 weeks and is not particularly uncomfortable, is £3,000. So you may say that they didn't succeed, but can you really say they didn't want to?
With the greatest respect, absolutely. Your Lordship has written a statute that isn't there, and B, sought to draw from the extra parliamentary material something, again, that simply is not there.
I just read it out.
No, my lord, you haven't read out a part, respectfully, you haven't read out a part that says all of that, because that is, again, an overreach. Parliament was very careful. Parliament could have said, all small claims, we're going to completely revise the Judicial College guidelines. They could have done that quite easily. They could have set a scheme for all injuries.
I know your submission is they didn't succeed, but what I'm balking at is the submission that they wouldn't have intended to if they'd known what the displacement activity would follow.
My lord.
The interesting thing is that in the explanatory memorandum,
Yes, my lord.
the formulation of the government's purpose wasn't quite the same as my lord's. Because on page 387, in June 2017, the Conservative Party formed a government with a manifesto commitment to reduce insurance costs for ordinary motorists by tackling the continuing high number and cost of whiplash claims, not small claims in general.
My lord, that is my submission. That it is a focused intervention, and the reason we set out, and we also provided the explanatory memoranda of the regulations, because again the point is made very cleanly in the regulations. If you go on to page 400,
actually the words are whiplash related. But, anyway, we can argue about
well, my lord, no,
the explanatory
that says my lord.
It
says
not law.
My lord, it says whiplash claims. It does not say whiplash related claims. At paragraph 3 on page 387, by continues to tackle high number and cost of whiplash claims, and you drop down
3.4. Anyway, don't worry. Let's not.
My lord, yes. But just my lord, but it is important. At page 400 in the explanatory memoranda of the whiplash regulations 3.4, the department has reached a view because the purpose of this legislation is to address the continued number and cost of whiplash related. That's the related personal injury claims, as defined in Part 1 of the CLA 2018. And that is, as we know, entirely addressing and only addressing what we call qualifying whiplash injuries. And that's why I was at pains to set out in our written submissions what's otherwise not necessarily entirely obvious, just because it's agreed between the parties, namely that it captures all qualifying whiplash injury claims, whether you have an additional injury or not. Which of course it needs to fulfil the policy, but it's a step that needs to be taken in the analysis. We set that out in our written submissions. In other words, its driver is simply whiplash injury claims that qualify, whether you've got additional injuries or you haven't got additional injuries, but at the same time it's only qualifying whiplash injuries. So, my lord, I can only say we really encourage a careful reading of the extra parliamentary materials with a weather eye to our submission that it is actually entirely focused on whiplash, as is echoed in the terms of the statute. See sections 1, 2 and 3, 1, 3, 2. It's super precise. It defines the whiplash injury, etc. at section 1, and then it goes on and it says, it's 3.1, this is page 8 in the authorities bundle. This section applies in relation to determination by a court of damages for pain, suffering, loss of immunity in a case where a person suffers a whiplash injury, etc. And then 3.2, because 3.1 and 2 work together, need to be read together. The amount of damages for pain, suffering, loss of immunity payable in respect of the whiplash injury. The injuries is just because you can have a back and a neck at the same time. I just always call it injury for convenience. Is to be an amount. Not full compensation, just fixed by law is to be an amount. So it's all the other way round. Once it's recognised, so the step I was at, my lord, in relation to this part of my case, is to say that there is no purposive of interpretation of section 3, which permits the overreach into the world of changing the test for legal causation for the non-scheme injury. And that's because its attention is exclusively in relation to the qualifying whiplash injury. And it is the other way round because of the presumptions in favour of the minimum interference with the pre-existing law, and the pre-existing law is the common law. And Lord Briggs confirms that, but it's common ground. We all know it is the common law in relation to the non-scheme injury. So it's
Briggs or Sumption?
It's Lord Briggs in the opinion in the AG and St Helena just confirms that the law of St Helena mirrors the law in relation to non-pecuniary damage, which is the common law. I'll give you the page now, my lord. So it's page 300, paragraph 16. In which Lord Briggs says it's common ground that in general the quantification of PSLA damages in St Helena is a matter governed by the common law of England. It's the common law of England which governs pain, suffering, loss of amenity. It's a common law construct. It's why the reference that we've made to the judgment of Lord Sumption when he sets out his presumptions we say is equally apt, because defamation exists at common law, as Lord Sumption says, and then in steps Parliament with a limited intervention. And so you have to read that limited intervention against the backdrop of the common law and with the presumptions which we sought to set out in our written submissions. And those are paragraph 19 of our written case. Parliament is taken to have known what the law was prior to the enactment. There's a presumption the statute doesn't alter the common law unless it so provides either expressly or by necessary implication. Expressly, I'm going to come to section 3.8. By necessary implication, not just, I sense a broader purpose behind Parliament's first step of many. That's not the position. Parliament has chosen to date, and it may decide this doesn't work and go home and revoke the Act. We don't know what it will do. But all it's done is a very focused, limited, partial intervention. So there is no prospect of reading that legal causation for the non-scheme injury is somehow changed by necessary implication. It would have to be expressed. And further, there's a presumption Parliament has not altered the common law further than it was necessary. It's like a test for proportionality under the Human Rights Act. That's sort of the same idea. No more than is reasonably necessary. And we've even got the defendant saying we accept that the non-scheme injury is governed by the common law, and I've made my submission as to what the common law does as a, if you like, a slight enlargement upon the observation of the court, which already captures the point in relation to concurrent injuries. And that has to have affected a wholesale change. That's what's involved if the defendant's submission is right. My third submission, my lords, my lady, is that the defendant's case is inconsistent with the wording and approach of section 3.8 of the 2018 Act. Can I invite the court just to go back to section 3.8, please? So it's pages 3.8 and 3.1, so it's pages 8 and 9 of the authorities bundle. And see the observation of my Lady Justice Nicola Davies this morning. 3.8 has to be read after you've read 3.1 and 3.2. And what do 3.1 and 3.2 do? They do something which I would describe, until gainsaid, as unique. Certainly no one has yet found another working example of this partial intervention. So either unique, or we can't think of one, and possibly the court will, through its greater knowledge of the law, but in any event, it's unique or close to unique partial intervention. It's partial because it's taking one person who sustained one group of injuries and it's dividing those injuries into two. And this is the absolutely key point that we make. This is what Parliament is doing. It is saying, you, the court, must make two separate awards. It's saying that because it's saying you must make this award for this element of the claimant's overall injury picture. That's
It's not making different. Just picking up on your use of language a little bit.
Yes, my lord.
You could describe it as being a different, as creating artificially different heads of damage. But what ultimately the court is seeking to do is to arrive at one award.
Not exactly, my lord. No, I wouldn't.
But
Respectfully, I wouldn't.
in relation to pain, suffering, and loss of immunity, in these cases, there are two things that you have to have regard to. One is the whiplash claim, and one is whatever is not in the scheme. And you have to put in the portal the figure you want.
My lord, yes. Is the court ultimately making one award for pain and suffering? Absolutely, because you can add two figures together and you get one figure.
Particularly where 3.8 applies.
Well, 3.8 support, in my respectful submission, I'm going about to come to it, but understanding the effect of 3.8 involves understanding this fundamental point in my respectful submission. So what Parliament is doing isn't saying, please come to an overall figure at all. That is exactly what it's not doing. You come to an overall figure by a process of addition in the same way that you come to an overall figure for the amount of damages the claimant recovers, because you add up the physiotherapy, you add up, in a complex case, many heads of loss and all the rest of it, and you put it in your calculator and you get an answer. You add interest, you get another answer, and you say judgment for that amount. But the court didn't holistically reach that figure. It reached that figure by a series of discrete and separate steps. And what Parliament is requiring the court to do here is to take two discrete steps. That is what, as a matter of statutory interpretation, is required in my respectful submission. And so the mere fact you add them up and then say, the overall pain and suffering is one figure, is a detail for the purposes of this analysis. And see the observation by Lord Justice Stuart-Smith. That is what the OIC requires. It's what the pre-action protocol requires. The compensator has to make an offer in respect of each individually. That is what is happening on the ground to make this a workable system. In the same way, and this may seem academic or arid, but at least in my mind it seems to help to understand that the claimant could say, I'm just going to appeal the whiplash element because I think you put me in the wrong bracket. You might think it's a bit of a mistake if someone's managed to get you in the wrong bracket, but let's just say papers are rushed and it's not noted that it actually said by the end of July, and the learned judge added up that to be 7 months and it's actually 9. And so there's been a mistake, one can imagine. You should be able to appeal the whiplash element and say, I'm not happy with my whiplash element. It's fixed by law and you got it wrong. I'm not appealing, in that sense, my overall pain and suffering. I'm appealing the whiplash element. You were required by 3.2, the amount of damages the court should award is an amount specified in regulations. You got it wrong. That is a discrete issue subject to a discrete appeal in an appropriate case. It may help in the analysis. It helps me, it may or may not help the court to see it that way. It necessarily follows that that which is left, the non-scheme injury, is to be assessed separately and discreetly. That must follow. And that is an assessment, as I say, which is undertaken according to common law principles. And then when one goes to section 3.8, the first part of 3.8 we set out in our written submissions, and I don't think it's actually in issue between the parties, but why it is that reference to an amount of damages is reference to the overall added up figure. So I'm in 3.8 at page 9, my lord, of the authorities bundle, and the nothing in this section prevents awarding an amount of damages. And that's because, as my learned friend Mr. Williams says, because it ends up saying subject to the limits imposed by regulations under this section, which would make no sense unless it was referencing the total figure. Can I just go back then to the words nothing in this section prevents? And the court will see straight away that section 3.9 uses the same language. Nothing in this section prevents the amount of damages payable being reduced by virtue of the Contributory Negligence Act. Now, the Contributory Negligence Act has the force of law, and Parliament's use of the language nothing in this section prevents, we've described, I think it's paragraph 54 of our written submissions, as an express saving mechanism. That is not a may issue at all. It's not a you can issue, it's thou will. It's saying nothing we're saying here prevents the application of the law relating to contributory negligence as we all understand it based on the 1945 Act. So not only are you going to get only £480, but it might be halved for 50% contrib. So that's the language that's being used. So when it says nothing in this section prevents, it's just an express saving mechanism. And then what is being said is when you award the total pot, nothing prevents you awarding an amount of damages that, open inverted commas, reflects the combined effect of the person's injuries. Now, if we then go back a step and say, what have we just accepted on the basis of the effect of sections 3.1 and 3.2? Sections 3.1 and 3.2 carve out the scheme injury. There is no discretion afforded to the court. We don't have to consider the exceptional circumstances to understand how the system works. Save duration of symptoms to put it in a tariff. But so essentially there's no discretion. You find the right duration, you put it in a tariff. Put a different way, if I can put it this way, there is no moving part. It is fixed by law. That's what we say, echoing words I think used in the OIC, and it's right. So when Parliament says to the court, you can award, and effectively it's saying you should award, nothing that this Act is doing stops you applying the common law and awarding an amount of damages for pain, suffering, loss and immunity. Whilst that refers to the overall figure, the figure for the tariff injury is fixed. So that is an invitation to the court exclusively to focus on the only moving part, which is the assessment of damages for the non-scheme injury. And when you assess the amount of damages for the non-scheme injury, Parliament says you can reflect the combined effect of the person's injuries, which is to say you will apply the common law exactly in line with the presumptions set out by Lord Sumption. You will apply the common law and answer the single question: are the symptoms caused by the knee, caused brackets or materially contributed to? If yes, you recover damages for it. That is what reflecting the combined effect does. That's what it achieves. It says if it's combined, it doesn't matter. You're still recovering for it in relation to the non-scheme injury. And we see this, if you like, it's confirmatory of this analysis in my respectful submission when you go to the Sadler case, because you will see, we've suggested, the court may or may not agree, that the parliamentary draftsman has effectively borrowed this language from the para 34 in Sadler, which is at page 277, and I'd invite the court just to turn that up, please. It's page 277 of the authorities bundle. It's a very particular expression, reflect the combined effect, and we actually find it used by Lord Justice Pitchford at para 34, which I think has been sidebarred. So there's a paragraph in which, in an exclusively common world, a common law world, Lord Justice Pitchford says, it's my judgment always necessary to stand back from the compilation of individual figures, whether assistance can be derived from comparable cases or the JSB guideline advice, to consider whether the award for pain, suffering, loss of immunity should be greater than the sum of the parts in order properly to reflect the combined effect of all the injuries on the injured person's quality of life. And as we set out in our written submissions, he carries on and says, or you can have a negative effect, or you can have no effect at all because they're totally separate. And Parliament has drawn out the very language used when there's what we describe as a synergistic effect, or my learned friend Mr. Allen describes as an aggravating effect. So Parliament is saying even in that scenario where the whiplash has rendered your knee worse, and a working example of this that's not outlandish, it may or may not assist the court, is if the whiplash has kept the claimant awake at night, and as a result of being awake, the claimant has felt the throbbing of his knee or her knee through the night, then the claimant has experienced more knee pain than would otherwise have been experienced without experiencing the whiplash. That's a sort of, I hope, grounded example of the synergistic effect. And Parliament is saying, where there is this combined effect, you recover for your non-scheme injury. Because that's the only thing it can be focusing on, Section 3.8, when the other part is fixed. There's no discretion according to the court. And Section 3.8, when you go back to its language, is an invocation to the court. Nothing in this section prevents a court. So this is what I would describe as, respectfully, an instruction to the court. And there's no ability to apply the instruction save in respect of the non-scheme injury. And that is why, in my respectful submission, my Lord, we say that Section 3.8 provides the answer in the case.
If you're right about that, why are the words in brackets at the end there?
Because the way they've chosen to set it out, it is by referencing an amount of damages overall.
I don't understand that.
I sought to make that submission earlier, my Lord. The part that says awarding an amount of damages,
Yeah.
that, when read with what's in parentheses, shows that that's the overall amount.
Okay.
So those two run together. That's how Parliament has chosen to draft it. If I could put it a different way, my Lord, had Parliament intended what my learned friend submits is the right answer, it would have been entirely straightforward to draft it, because, and I am no legal draftsman, but words to the effect of, where the claimant sustains a non-scheme injury, the claimant is limited to recovering only that additional pain, suffering and loss of immunity to that which has also been caused by the whiplash injury. That's what they say this Act provides for, and that is easy to plead, to set out in a much more attractive way than I've sought to do just there on my feet. But it's very easy. And it's absolutely not what Parliament has said. It's borrowed words from the exact opposite position of synergy, not overlap equals reduce. And consistently with that, we made submissions in our written submissions how this is the only way that you can reach a just and fair assessment of quantum for the non-scheme injury. And so now in response, finally getting there to the observation of my Lord Justice Stuart-Smith and the suggestion that if I'm wrong on one earlier part, I'm still hit by what I might loosely call a sort of Sadler discount. The Sadler discount has no application in this case. The Sadler discount only applies in the context of the court's overarching obligation to provide full restitution, full compensation, 100% compensation. It is the only circumstance in which the court is then charged with the obligation to ensure that it stands back and takes a view. The standing back and taking a view is to ensure you neither under nor overcompensate. That is the function of that last step in the judicial function.
Is that your fourth point?
No, regrettably, my Lord, no. That my fourth point relates to the practicalities. This I include, whether it needs to be or not, include within my third submission, my Lord. It's getting to my apples and pears, my Lord. It's because the court cannot make any such overarching assessment. Now we've got an award for the non-scheme injury, we've got an award for the scheme injury. There is no standing back to be done because the court cannot make an assessment by reference to the full compensation principle when part of that which has been awarded has been fixed by Parliament at a suppressed level. It makes the task logically impossible for the court. It's para 57 of our written submissions. In which we say it's not only the court's being asked to compare apples with pears, it's that the court doesn't have the task of finding a single figure for the combination of the fruit at all. The court is not charged with that task. It can't be charged because it can't achieve a task. This is why when one gets to the what should we do feel factor under the second or third cases which are being promoted, it's also artificial. It's also vague. It's also stand back and do what? What are you comparing? Like to like. There is no like to like to compare unless, and this is my practical point I'll come to, you effectively re-plead and re-argue the entire whiplash in the face of legislation. So can I come to my fourth submission, my Lord, which is that the defendant's case leads to highly undesirable practical consequences at odds with the whiplash reform programme. There's highly undesirable practical consequences at odds with the whiplash reform programme. Because if the defendant is right in its submission, the whiplash injury in every mixed injuries case requires to be assessed in some detail. And I believe that, well, one, my Lord Master Ross would have been sent this data straight away, and two, an observation from the bench suggests that the data has been read that arrived yesterday from the Ministry of Justice, producing an operational analysis of the first year of the OIC service. And I expect the court has that, but we're happy to include an electronic copy of that as well if it would assist. And for the period from the 1st of July 2022 to the 30th of September 2022, 67.3% of the claims presented were mixed injuries claims.
What percentage?
67.3%. And there are around 24,000 claims a month. So something like 15-odd thousand claims, 14 to 15, I think, thousand claims a month are mixed injuries claims. So, of course, this court understands the importance of this point. We wouldn't have leapfrogged here. But it's really important to the full and effective functioning of the OIC. So gone is the simple requirement.
Could you just tell me why it makes it particularly difficult?
Yes, my Lord, of course.
Yes. Well,
yes, my Lord.
Wait for the question. If most cases are, as we're told, cases where the same pain and the same loss of amenity anyway is caused by multiple injuries, and they're small injuries, so that what you're assessing is the pain and suffering for particular non-scheme injuries. Why does it make it particularly difficult if one were to say that in such a case what you're assessing is the pain and suffering caused by the non-scheme injury? You don't have to make any apportionment, you don't have to do any standing back. All you have to do is work out what is the proper compensation for pain and suffering of the injury that is not compensated by the fixed sum.
Well, part of that sounded like our case, and then and then it veered into what the defendant is actually requiring.
There was no veering, Mr. Weir. It was a very simple question. So let's not criticise the question. Let's
sorry,
try and answer.
no apologies. Yeah. No intention to criticise the question.
Try and answer the question rather than reanalysing it.
Yes, my Lord.
And I'll put it again if it would help.
No, my Lord. Can I just seek to try and address the issue?
Yes, why not?
My Lord, yes. So, if the defendant is right, the court needs to assess in relation to any pain, suffering, and loss of amenity, its causal genesis.
Yes.
Where has it come from? And it needs to assess specifically, has it come from the whiplash? Because all that's left on the defendant's case is the additional symptoms not caused or materially contributed to by the whiplash.
Yes.
That necessarily involves not an analysis simply of the duration of the whiplash injury as per the scheme, but a detailed analysis of the nature, quality, and cause of the pain, suffering, and loss of amenity. Loss of amenity may or may not be modest in one case, it may be, it may not be. But if one simply takes, for instance, time in hospital, is it that the claimant was in hospital for 3 days due to the whiplash alone? Is it that the claimant would have been in hospital for 2 days, but the knee and other bruising in the ribs kept him in hospital for an additional day? Well, it may seem silly, but
that's not what we're talking about. What we're talking about is pain, suffering, is an amount for pain, suffering, and loss of amenity. If he lost earnings by being in hospital, that's a different question. I mean, the issue here is in these small cases where we now know 60% include multiple injuries because of the, no doubt, the perverse incentive given by the legislation to do so, in those cases, is it particularly difficult normally to assess the pain and suffering of the other injuries separately? That was the question. Is it?
My lord,
I don't see
forgive
why
me,
it should be.
the inappropriate reference to Birkenhead was because I was, in my mind, to have a very clear division line. You either start with, which is our case, the non-scheme injury, and you ask a single question, has this been caused, brackets, or contributed by the non-scheme injury? If so, it's recoverable. Or you go down a defendant's line, which say, has it been caused or contributed by the whiplash injury? If so, it's not recoverable. When you engage in the defendant's process, you do have to. The hospital example, respectfully, is entirely apt because that's not about lost earnings. I'm talking about.
I understand that you're right, that there can be complex cases. My lady mentioned it this morning, you know, and she criticised the defendant's argument as saying, how can you possibly expect, when there's no evidence, to go into the causation of particular losses which are not specifically compensated in the scheme? So you are interrogating something that you are not required to interrogate by the new legislation. You're interrogating causation of particular aspects of the whiplash injury, which you don't need to look at, because that's the whole purpose of the legislation.
Yes, my lord.
I get that point, and that seems a powerful point for you, although it's not one any of you on your side has majored on. But what I don't understand is the fourth submission you make, which is this is highly undesirable practical consequences at odds with the whiplash reform programme.
Well, my lord,
because it seems to me both sides are advocating something that is less than ideal, and we've got to decide between two less than ideal solutions.
my lord,
Three.
I've given an example of hospital in 3 days because that's instead of just saying, oh, loss of immunity is only the playing of badminton, etc. Loss of immunity can be how long were you, not just off work, but because you may not have been working, that you're in hospital. That is a part of your, call it pain, call it suffering, call it loss of immunity. It's real and needs to be compensated. Analysing that out, if you are starting from a premise, the claimant has to prove additional losses not incorporated within the whiplash injury and has the burden of so proving, means that what started as a simple exercise will immediately, on any well-advised claimant, convert itself into a far more complex exercise in which the claimant has to analyse the extent to which he or she considers that he has suffered these additional symptoms, or that they've had this synergistic effect such that he wouldn't have been in hospital if he didn't play badminton for 2 weeks. Is it that the whiplash kept him off for the first week and yet the knee kept him off for the second week, as opposed to simply an assessment. Has the knee affected him in this way and kept him, has it materially contributed to his being in hospital for 3 days, which would be treated, if you like, in effect as non-divisible, absent better assessment, and the claimant would recover damages. This will be quite the reverse. Unless the claimant does all the heavy lifting, the claimant is going to be left facing exactly the sort of approach of the district judge, which is, in the Briggs case, I think, which is you didn't articulate any loss of amenity that's separate. Even the bins example, I don't know whether the bins is knee or back or whiplash, but it's unless the claimant works hard to establish that it's not just the knee, but it's the knee in a way that has nothing to do with the whiplash, the claimant will no longer be able to recover for that. That has converted a very straightforward process into a remarkably complicated one. Because you've got these it's remarkably complicated because you've got to go through, if you want to recover any money, think of the defendant's case in reality. It's effectively saying you're getting a few shillings on top of what you would have had, because that's the effect. They're saying it's a few £100 because really you didn't prove anything much additional. So what was a £2,500 award for the other bits and pieces now becomes £700 or the like.
All you need is for the doctor to say, so what stopped you putting the bins out? And the chap says, well, knees and whiplash, or whiplash for the first 6 months and then knees after that, or vice versa. What stopped you playing badminton? Well, I couldn't. My knees were shot and my back was hurt. It takes about 3 minutes, and then in these very simple, low value, high volume claims, the DJ does, or whichever level of court it is, does the best they can with the material that they've been given. And they make findings which are not perfect. It doesn't have the luxury of leading counsel on all sides, but it's a system of justice. It's the same for everybody. It's not difficult.
My lord, it is considerably more difficult when the claimant has to establish additional separate pain, suffering and loss of amenity than the claimant to say, my knee hurt, I was in hospital for 3 days.
You're right, Mr. Ware. It is your solution, for which you advocate, is undoubtedly the most clean cut. I mean, I think we can all agree with that. The solution that Mr. Allen advocates has the difficulty you've identified and the one I've identified. And Mr. Williams's second argument has the difficulty of what do you stand back and really do, and we see that in the two judgments. So we know there are practical difficulties, but we have to decide this case.
My lord, yes, but it's part of understanding what Parliament intended.
Yeah, I think we've had a look at this statute. Yeah.
Yes, my lord, but the submission isn't made simply as these are the practical sequelae, get over it. The submission is made as these are not the practical consequences that Parliament intended. That's the submission that's being made, my lord. Okay. So it goes back to the proper interpretation. Can I also seek to emphasise this, my lord? There's reference to what the district judge should do, but the district judge is the port of last call.
Yes.
This isn't really in that sense about what district judges should do. This is about a claimant, and very few, I think about 9% at the moment or something, are litigants in person according to the data which just came in, I forget, something of that order. A really small number, surprisingly small. The rest of them are giving away their damages in order to function within the system. Whether they should or shouldn't, that's what's happening on the ground. For a litigant in person, the litigant in person is going to be faced by a professional defendant making an offer. The litigant in person has been referred to the Judicial College guidelines, which are of no use on the defendant's case at all, because you're now in a world of additional symptoms only. The feel factor that district judges come to have, such as those of us who enjoyed whippy whiplash back in the day on a regular and recurring basis, got the feel of the right sort of level of award, is alien to the litigant in person. So this system is no longer functioning. It's completely stacked the deck against the claimant who faces an offer with no comprehension of whether that offer is a realistic offer or not. And that's not an effective system. Whereas if you say to the claimant, Did you suffer any injury, and did it feel like it caused you a range of problems sitting within this judicial college guideline that I'm referring you in the OIC to? That's the sort of figure you should be looking at receiving. It's a simple, efficient system that won't get through to a district judge and rely on their wealth of experience.
Yeah.
My Lord, unless I can assist further, those are the intervener submissions with great thanks and apologies for
Because
extending
it was
myself.
the longest 20 minutes.
I wonder if my 20-minute reply extends so long. I hope not.
Mr. Allen.
Grateful.
Just a moment.
No, thank you.
Sorry.
Thank you, Mr. Wood. Yeah.
A considerable amount of time was devoted to legal causation, material contribution and the right to full compensation. This appeal and this exercise before the district judge was not an exercise in causation, factual or legal. It was an exercise in quantification. Quantification for a claim against a single tortfeasor. My learned friend appeals to Bonington Castings, Williams in the Privy Council and so on and so forth. In his written submissions, there's no reference to the importance of legal causation or that strand or authority. It has absolutely no application whatsoever here. Material contribution is a test or aspect of causation when there are concurrent causes and an indivisible injury. Here, we have one tortfeasor, one cause, the road traffic accident, personal injury, completing the tort, and then within pain, suffering and loss of immunity, the non-pecuniary loss, the elements of the injury. So, appeal to legal causation, say, well, as a matter of material contribution, there would be entitlement here. The claimant has entitlement to damages as a consequence of the defendant's negligence. It's an exercise in quantification. And therefore, these aren't indivisible injuries. You don't even get into that arena because individual injury is the Bailey and MOD, the brain injury, which has multiple causes, one of which was negligent. Here, well, we've got injury to the head, to the neck. There's injury to the knee. They're completely divisible injuries. They're wholly separate injuries. And a judge would reach a view as to an overall award to reflect the totality of that in our respectful submission. It's not, my Lord gently shook his head in response to our submission, but this is an exercise in quantification, not determination of whether this is a legal cause.
I agree with that, but your submission introduces the concept of causation.
No, respectfully, it introduces...
Just because you want to apply everything which is caused concurrently by the whiplash and the other injuries, you want to stack entirely the compensation into the whiplash side.
So
you are effectively treating it as if it was only caused by the whiplash.
Mr. Allen, you can't get to quantification without causation.
But causation is already established, my lady. Causation of the accident, that accident resulting in the claimant's injury, is established straight away.
That's what we're talking about.
But I was answering my lady's question. Sorry, my lord.
Well, my lady is right, because you're trying to split elements of the claim. And you are saying that, but I think you accept that the whiplash may have certain effects, and that let's call it the knee injury, may have certain effects, and the effects of the whiplash and the knee injury may overlap.
Yes.
Well, I'm sorry to be technical, but in technical language, they are concurrently caused by the two. We don't have to. I agree with you. We don't have to go to Bonington or McGee or anything like that.
No, agree.
That's a red herring. But once you have concurrent causes and you've got this artificial regime, you've got a problem.
Well, you've that was going to be my submission, but it was a red herring. I'm glad we've got there. In terms of, it was part of the analysis that gets us to the concept of full compensation and almost the criticism of our use of the phrase double counting. Yeah. And because my learned friend wants to shift the analysis towards this causation debate, that's what he wants to anchor it to. The phrase double counting comes from Lord Justice Pitchford in Sadler. When he talks about the exercise of arriving at what is just, fair and reasonable, for your note, page 277, paragraph 34, and I'll just read it now to make the point. It is, in my judgment, always necessary to stand back from the compilation of individual figures, whether assistance has been derived from comparable cases or from the JSB guideline advice, to consider whether the award for pain, suffering and loss of amenity should be greater than the sum of the parts in order properly to reflect the combined effect of all of the injuries upon the injured person's recovering quality of life, and then my emphasis, or on the contrary, should be smaller than the sum of the parts in order to remove an element of double counting. That's what it flows from, and in our respectful submission, it's not into... again, as part of the exercise of quantification of providing compensation for the totality of the injuries, it is right to ensure that there isn't double counting. On the hospital example, you're not compensated for that twice. Otherwise, that would be overcompensation and it would offend double counting. If I stay with my learned friend Mr. Weir's submissions, the points that we want to come back on. Our response is the same as my lords and my ladies was at the outset, in terms of Parliament has dictated that, and can we look at the phrase, it's in the Act, back to the beginning of the authorities bundle, because my learned friend glossed over these words, he didn't include them. If we look at, for example, 3.2 at page 8 of authorities bundle 1, the amount of damages for pain, suffering and loss of amenity payable in respect of the whiplash injury or injuries. All of the pain, suffering and loss of amenity attributable to the whiplash injury or injuries is compensated by an award, and he became comfortable with the phrase, compensated by an award of damages which is an amount specified in the regulations. The interveners may hold the view, and as a matter of fact it's accurate, that under this legislation claimants now receive less than they would have done on a historic common law assessment of these injuries. But that is the effect. There's no way around that. You may not like it, but to suggest that, well, because Parliament hasn't provided a figure that mirrors what would have been previously avoided, they're not receiving full compensation for that element of their injuries is fundamentally wrong. And so when we come to the assessment exercise there...
Sorry, can I just get this clear? So you are saying that this might be called a statutory award, rather as we have the fatal statutory award. Are you accepting that?
Well, no, my lady, because when we look at 3.8, and 3.8 talks about the making of an award, the way we've analysed it is, and hopefully in our submissions have been consistent, there are two elements to the PSLA award. There is the element which is set by Parliament, in respect of the whiplash injuries and minor psychological...
That's the one I'm looking at.
Pardon?
That's the one I'm looking at.
Yes.
The one that really is specified by 3.2. Are you accepting that that does not represent full compensation?
No, I'm not accepting that.
Well,
The figures that... Sorry.
Forgive me. I'm probably phrasing it wrongly. It is clear that it is an award that is set pursuant to this statute.
Yes.
Yes. Do you take it further and say it is not only the award set by this statute, as a matter of fact, it represents full compensation?
By definition, the claimant... Yes, it does. That for the whiplash injury, for such injury as falls within the tariff, by Act of Parliament and then the regulations, a claimant receives full compensation for that injury by that amount. Because
it meets the statutory award as opposed to any award that it might have met applying common law principles.
Yes, now in these claims, that's the only award. That's the award that a claimant who suffers injury of this type, qualifying within the terms of the Act, that is the award they receive by way of an award of damages. That's why I emphasise the words of the subsection, as an award of damages for pain, suffering and loss of amenity payable in respect of the whiplash injury. That is full compensation for that injury. The number is lower than it would have been before.
Significantly.
It is. But it doesn't mean it isn't. By Act of Parliament, that is now what represents full compensation for that injury. In our submission, and we get the explanatory notes and so on, they identify there's no qualification for that. That award represents compensation for that element of the injury.
Well, I don't have any trouble with that award represents the compensation you get for that element of the injury. And I'm not yet sure that you're doing more than arguing about words rather than substance, because what the explanatory materials and common knowledge make clear is that this was a political package of measures which on the one hand led to an improved portal scheme, if you think it's an improvement, simplified for everybody, quicker justice, so on and so forth. But one of the quid pro quos, if you'd like to call it like that, was that instead of talking about full compensation, they talked about proportionate compensation. Tended to. And everybody, I mean, there is a conflict which you can't get round between the levels that you get under the scheme and what the common law has said is full compensation. You can't get round that.
No.
But surely where you're on much stronger ground is simply to say that is what Parliament says you get.
Absolutely, that is our solution.
And for a whiplash, that doesn't answer the question what you get for your non-whiplash.
And what you get for your, well, and what I'm trying to do is focus on responding to the points that are made. We had a long exchange this morning. We did trying to set out our position. But it is because the reason I go to that, and my Lord indicates that my lady possibly has a degree of unease with it, but my Lord says, well, one can understand that as a matter of the Act of Parliament, in respect of the tariff injury, that represents full compensation, Parliament balancing the competing factors as it has deemed appropriate. The reason that's important is my learned friend's gateway to his argument about, well, because this is not full compensation for that element of the ward, you now can't have an exercise where you can adjust the non-tariff. Once that pillar of his argument goes, then it follows that it is perfectly legitimate where you have what Parliament says is full compensation for the whiplash, and a judge making a common law assessment of what they consider is just fair and reasonable for the non-tariff, that you can have the adjustment to reflect overlap and so on. You can have the exercise where you focus on what is additional, recognising that the whiplash element has already been compensated. That's the reason we go to that. What else did we have from Mr. Weir? Oh, I think on his language, or the reference to the language in 3.8 and the reference back to Lord Justice Pitchford and the reference to combined effects, and the synergistic case. Briggs and Rabot are not synergistic cases. So it was never argued that the effects of the injuries, not only did the district judge expressly not find there was synergistic effect, it was never argued that there was synergistic effect, so that the impact of the whole was greater than the individual components. And in fact, not only was it not argued, in Rabot it was conceded that reduction and adjustment was appropriate because it was a true overlap case. So if the language for 3.8 is unique to the synergistic, then we have no legislation for the overwhelming majority of cases where there's overlap requiring reduction, we say. And that demonstrates the fallacy of that line of his argument. The making of offers. My learned friend prays in aid that the portal requires identification of what the offered tariff element is and what the offered non-tariff is. That's not because they're two wholly separate awards. It's in order to police the portal to see that the appropriate award is being put forward, particularly for litigants in person, so that they can see, is the figure for my whiplash, based upon duration of symptoms, as it should be according to the tariff. It provides transparency so that litigants in person or others can see that's an accurate application of the tariff, and then this is the proposed figure in respect of the rest. And in terms of appealing, it would be, it's not individual elements of a decision that are appealed, it's the overall award. You appeal the judgment overall, and you appeal the order that was made. The order would have a figure for PSLA damages. You would appeal that and say it's too low because in the assessment, the tariff element was too low on my learned friend's hypothetical. He criticises the defendants because we're complicating the proceedings by reference to burden of proof. We're not presenting the claimant with a burden of proof that hasn't always existed or shouldn't exist. It's for the claimant to demonstrate what pain, suffering and loss of amenity is attributable to the accident and to his injuries and what the appropriate award is. Turning to my learned friend Mr. Williams' submissions starting before lunch, hopefully to try and take them in the flow that he made them, I think his starting point was, well, to demonstrate the flaw in the defendant's argument, let's switch it round and let's start with the knee and not start with the whiplash. And he took the district judge's figure of 2,500. The flow of the submission was effectively to regard that as a fixed award, a fixed element, but it isn't. That's the element of the award, the non-tariff, which is evaluative and can properly be adjusted to reflect overlap and the limit of impact. So that on my Lord, with the exchange with my Lord Justice Stuart-Smith, you should be able to take one or the other first, it shouldn't matter, with which we agree, because when we come to the only element in this exercise that can be adjusted is the non-tariff. So rather than saying, well, you've got this award for the knee injury, it's almost lightly penciled in 2,500. You then look at the whiplash injury and identify as here, that's the dominant injury, that is the injury which is actually responsible for the bulk of the pain, suffering and loss of amenity. You then look at your penciled 2,500 and say, there needs to be adjustment to that, reduction to that, to recognise the fact that all of the bulk of the pain, suffering and loss of amenity has been compensated by the whiplash injury, and you adjust that figure to acknowledge that. And they should lead you to the same outcome. They shouldn't lead you to different points, because the principle for the non-tariff is what is just fair and reasonable. If the perfect performance of the exercise, wherever you start, you should lead to the same end point. But what we say, the reason we suggest starting with the whiplash is, that is fixed, and it allows the court to then focus on what is over and above that which is compensated by the tariff award. In this, it's said against us, we take 2 pages to explain our approach. We identify the principles or the rationale that sits behind it, but it's a simple 3-step process. Findings of fact as to the impact of the injuries, setting the tariff figure, and then 3, evaluation of PSLA for the non-tariff. My own friend Mr. Williams said, in the real world, in a real Birkenhead or St. Helens case, you wouldn't have a judgment like this. He's absolutely right. You wouldn't have a judgment like this, because we anticipate after the decision of this court, district judges won't have to be analysing the arguments that District Judge Hennessy had to analyse in terms of what's the correct approach, what's the impact of Sadler, what's the scope for adjustment, and so on and so forth. If we look at DJ Hennessy when she comes to valuation, my preference has been to work from Rabot. Rabot core bundle, please. Judgment starts at page 70. It's almost a potted version of a King's Bench decision where claimant submissions, defendant submissions, legislative framework, discussion and then conclusion. All of the first phases where there's reference to the legislation, the competing arguments on the point of view, the principle, the quote from Sadler, they all get stripped out. In fact, when we get to conclusion, the sort of findings, we've got, what would the district judge need? Probably at page 72. At page 72, starting at para 10, the district judge recounts the claimant's submissions as to what the injuries were. That's effectively recounting what's in the medical report. It's almost verbatim from what appears there. So you'd have that. There was no major challenge to that from the defendant. The debate was about the numbers. And then we get to page 77. Although they're thin, the district judge makes findings of fact, then produces a figure. On our approach, it's that 2 or 3 sides, no more. It wouldn't even be reserved. It would be an extempore, but with a structured, disciplined approach, working through, producing a final award. So the implication that if we go down the defendant's road, we will have judgments like that is simply wrong, because the bulk of it is nothing to do with the simple quantification exercise. A point my lady, a concern that she had, I think, in exchange with Mr. Williams was about, well, on this debate about loss of amenity, we'll move towards claimants having to do witness statements and so on and so forth. Can I just give you an example of what it is that these claimants filled in order to present their claims? Sorry, my lady, bear with me. So could we take page 40 in the Rabot supplementary bundle, please? Now, bearing in mind, I think on Mr. Weir's statistics, 91% of claimants are represented, and we have the majority of the mixed injury claims. Here you have the small claims notification form. This doesn't mirror perfectly what people see on screen as they're going through. For example, we don't see the questions or text or drop-down boxes necessarily, but this is the form that's created once they have filled in the notification form for the online portal. And can I invite you please to turn to page 45? So at 45, there are a series of headed prompts asking claimants to indicate whether they had a particular type of injury. And obviously, unsurprisingly, we start with whiplash. But the box that's immediately below that is one of those free text boxes. So an individual can include any text there that they want to, describing the severity of their injury or their symptoms. They don't have to draft a witness statement or provide one. The portal is geared to prompt and create the opportunity to provide such information in a very structured fashion as is necessary and appropriate. So here, with the benefit of solicitors, it just says the claimant suffered from neck pain and stiffness. If the claimant wished to describe the impact of particular injury upon them, then they can do that there, and that can be uploaded as part of the process. And following that, for example, here, in Rabot, it was a knee injury. There's a box there, a text box, leg, knee, ankle, foot, toe, sprain or strain. So the claimant suffered pain in both knees.
Forgive me, what page are you on?
I'm still on 45, my lord.
Thank you.
I'm just working down.
Yep, got it.
So that there is, the portal creates the opportunity. It doesn't create an extra burden upon the claimant to go and produce a document that they're not acquainted with, and then having that uploaded. The opportunity is there to provide any extra information. And so now, in 91% of cases, solicitors will perhaps appreciate the importance of providing some information if it's considered helpful and necessary. So what we're suggesting, and that's opportunity 1. Opportunity 2, whether by video link or face-to-face, there'll be a medical assessment, and as my Lord Justice Stuart-Smith said, it's a handful of questions to say, for example, which injury had the greatest effect upon you? What was most difficult? And here, we know the knee injury was over at 4.5 months. If the claimant was still struggling with badminton after 4.5 months, then it's the whiplash that's the cause of it, because factually it's there. So, in our respectful submission, unrepresented and represented claimants have easy opportunities to provide any necessary information which would assist in valuation of their individual claim. the contribution point, the sort of the illustration of, well, what about if tortfeasor A causes the neck injury and tortfeasor B causes the knee injury? I'm going to tread very carefully, given my lord could quote the statute from memory rather than on screen. But those tortfeasors are responsible for different injuries. They are not liable in respect of the same damage. One's caused one injury and one's caused another. So tortfeasor A hasn't caused the whiplash injury, they've only caused the knee injury. They would have no liability in respect of the whiplash injury. Conversely, so a contribution claim between them, in our respectful submission, wouldn't arise. In this hypothetical, and they're separate tortfeasors, we're looking at one tortfeasor. One tortfeasor who has caused personal injury. The tort is completed. As an aspect of quantification, you have to now allocate awards the elements of it. After lunch, from a learner friend, Mr. Williams, I don't think there's anything else we need to pick up there. Can I just check if there's any other points?
No. I don't think he's right about the contribution act, but I'll look at it some other time.
You don't think?
I think he's right about the contribution act, but I'll look at it.
No. Thank you very much, Mr.
Thank you, my lord.
Allen. Well, thank you all very much for a very interesting argument. We will consider judgments and hand them down in the usual way in due course. I'm sure you'll take note of the strictures in Counsel General for Wales and make sure that you use the draft judgment only for the purposes for which it's intended, particularly in a sensitive case of this kind. It's particularly important that you provide my clerk with the appropriate contact details and that the judgment is not disseminated further except for an appropriate purpose. Then when you get the draft judgment, please use it to agree costs and consequential directions, and if you can't, we'll deal with that matter in writing. Thank you.
So, my lord, just before you rise, I just have one factual point to make, one sentence. But my learned friend showed you the claims notification form and said you can upload material there about the facts. But I think the boxes he showed you, and I suspect this is common ground, those are the boxes I refer to where there's a 500 character limit, including spaces. So there's only a limited, there's a limited scope.
Before my lords and my lady rise, just picking up on your point about obviously the interest and the sensitivity and the importance of the issue. Very gently, might my lords and my lady have any sense of a time scale for a judgment?
All right.